You are not signing this.
Get your hands off me. These documents are mine.
Stop it, both of you!
The closing documents were signed on a Thursday afternoon in a title company conference room that smelled like coffee and carpet cleaner, the way all title company conference rooms smell, as though the scent is required by some professional standard I am unaware of. The buyer was a land development company called Meridian Ridge Partners, represented by 2 attorneys and a very quiet man in a gray suit who I understood to be the principal. The seller was me. The property was 214 residential lots within the Clearwater Estates planned community, encompassing every home, every common area, and every inch of infrastructure. The Clearwater Estates Homeowners Association had been managing, improving, and assessing dues against for 11 years, built, as it turned out, on land that had never legally left my family's ownership, conveyed in a fraudulent transaction that the HOA's founding developer had recorded, with the county in 2009 using documents that a forensic title examiner would later describe, in a court filing, as among the most comprehensively fabricated instruments I have reviewed in 32 years of practice. I did not celebrate when the closing was complete. I shook hands with the buyer's attorneys, thanked the title companies, staff, and drove home on roads I had driven since childhood. It was a Thursday. I had things to do on Friday. To understand how 2,000 acres of family land ends up at the center of a real estate fraud that takes 11 years to fully unravel, you have to understand what that land was and what it meant, and how easily its significance can be obscured when the people responsible for obscuring it are sufficiently motivated and the county recording system is not designed to catch sophisticated forgery. My family's land in eastern Tennessee had been assembled over 3 generations, beginning with my great-grandfather, Amos Delbert Crane, who purchased the first parcel, 400 acres, of mixed hardwood and bottom ground along Clearwater Creek in 1931 during the Depression, when land prices had collapsed, and Amos, who had spent 20 years saving the wages from a railroad job, was one of the few people in the county with cash money to spend. He was not speculating. He was building something. He bought adjacent parcels over the following decade as they became available, always at fair prices, always with properly recorded deeds, always with the specific patience of a man who understood that land assembled carefully over time was a different thing from land acquired quickly. By 1955, the family held approximately 1,400 acres. My grandfather added another 600 acres in 2 purchases during the 1960s, bringing the total to just over 2,000. The land was used for timber, cattle, and the family's personal use, a working landscape carefully maintained, with a history in the county records that was unambiguous and complete. My father inherited the land in 1988 and managed it the way his father had managed it, which is to say carefully and without drama. He sold timber rights on a sustainable rotation, ran a small cattle operation on the bottom ground, and kept the ridge timber intact because he understood, the way foresters understand, that old-growth hardwood is worth more standing than cut. He died in 2019, and the land came to me. I was 54. I had spent my career as a civil engineer in Knoxville, and I had been involved in the land's management throughout my adult life, returning on weekends and holidays, maintaining the fences and roads, keeping the tax payments current, and the deed records clean. The inheritance was not a surprise. My father and I had discussed it at length over the years, and I had always understood that the land would be my primary responsibility when the time came. What I had not understood, because my father had not known to tell me, and because the fraud had been designed specifically to avoid detection, was that approximately half of the family's land had been the subject of a fraudulent conveyance recorded 7 years before his death. The discovery happened the way important discoveries usually happen, not through dramatic revelation, but through the ordinary process of doing something you should have done earlier. 3 months after my father's death, I hired a title company to conduct a full examination of the family's land holdings as part of the estate administration process. The examiner, a woman named Louise Garrett, who had been doing title work in the county for 28 years, called me on a Wednesday morning with the tone of someone who has found something they wish they had not found. She said she needed to meet with me in person. She said it was not something she wanted to discuss on the phone. I drove to her office that afternoon. What Louise had found was a deed recorded in 2009, 9 years after my father had last commissioned a full title search and 7 years before his death, conveying approximately 1,040 acres of the family's eastern tract to an entity called Clearwater Development, LLC. The deed purported to be signed by my father. It was notarized. It was indexed correctly in the county's recording system. It referenced the correct parcel numbers and legal descriptions. And it was, as Louise explained with the careful precision of someone who understood the legal weight of what she was saying, a forgery. My father's signature had been falsified. The notarization had been fabricated. The transaction had never happened. My father had never sold that land, had never met with anyone from Clearwater Development, LLC, had never received any payment, and had, in fact, continued paying property taxes on the parcels for the 7 years between the fraudulent recording and his death, which was itself a significant piece of evidence, since a seller who had genuinely conveyed property would not typically continue paying taxes on it. And the county's tax records showed continuous assessment in my father's name throughout the period. Clearwater Development, LLC had used the fraudulently acquired land to build Clearwater Estates, a planned residential community of 214 homes, a clubhouse, 2 parks, a community pool, and approximately 4 miles of private roads, all constructed between 2010 and 2014 on land that had never legally left my family's ownership. The developer had subsequently dissolved the LLC in 2015, at which point the remaining undeveloped land and the community's common areas had passed to the Clearwater Estates HOA under a deed from the dissolved entity, a deed that was itself invalid because the LLC had never held valid title to convey. The 214 homes had been sold to individual buyers who, as far as I could determine, had purchased in good faith from what appeared to be a legitimate development. They had not participated in the fraud. They were, in a meaningful sense, also victims of it. I retained an attorney named James Whitfield, who practiced property and fraud litigation in the eastern Tennessee region and who had, over a 30-year career, handled several cases involving fraudulent conveyances and title chain corruption. James reviewed Louise's findings, commissioned a forensic document examination of the 2009 deed, and within 60 days had assembled a factual record that was, he said, as clear a case of real property fraud as he had seen. The forged signature was confirmed by a handwriting expert who compared it to 32 authenticated samples of my father's signature from the same period. The notary whose seal appeared on the document had died in 2007, 2 years before the deed was purportedly notarized. The recording had been accomplished through a county clerk's office that, subsequent investigation would reveal, had processed the document without the standard verification procedures because the filing had been accompanied by what appeared to be a legitimate attorney's certification that the instruments were in order. The certification was also forged. During the period between Louise's discovery and the formal legal proceedings that followed, I received, in the ordinary course of managing the estate, a certified letter from the Clearwater Estates Homeowners Association. The letter was from the HOA president, a man named Gary Whitmore, and it informed me that a portion of my remaining land, the western tract that the fraud had not reached, was in violation of Clearwater Estates community standards, specifically because a fence line along my property's boundary was inconsistent with community aesthetic guidelines, and because my cattle, which grazed the bottom ground along the creek, were producing what the letter described as noise and odor impacts on community residents. The fine was $400, with escalating penalties. The letter also noted that continued violation could result in the HOA seeking an injunction against agricultural use of my land. I read this letter with a feeling that I will not describe as irony, because irony is too small a word for what it felt like to receive an HOA violation notice about my cattle from an organization that had been built on land stolen from my family. I put the letter in a folder. I did not respond. I called James instead, and I told him that the HOA had just made contact and that I thought it was time to begin the formal proceedings. He agreed. He said he had been ready for several weeks. The legal strategy James developed was comprehensive and, I thought, elegant in the way that solutions are elegant when they address a problem at its root rather than its surface. The core claim was straightforward. The 2009 deed was a forgery. The conveyance was void ab initio, meaning it had no legal effect from the moment it was created. And therefore my family had never ceased to be the owner of the Eastern Tract. If the conveyance was void, then everything that flowed from it was also legally infirm. Clearwater Development LLC's ownership, the construction permits, the lot conveyances to individual homeowners, the HOA's claimed ownership of common areas, and the assessments the HOA had been collecting for 11 years. James filed the suit in circuit court in the fall of 2020, naming the dissolved LLC's successor interests, the HOA, and the county recorder's office as defendants, and seeking a declaratory judgment that the 2009 deed was void and that fee simple. Title to the Eastern Tract had remained in my family continuously. The HOA's response, filed through their attorney, was to contest the forgery claim and assert that even if the original conveyance was defective, the subsequent bona fide purchasers, the individual homeowners, had acquired valid title through the normal operation of Tennessee's recording statutes. This was a legitimate legal argument, and James had anticipated it. He had also, while the HOA was preparing its defense, been conducting a separate and parallel investigation into the title chain of the individual home lots, which revealed something that the HOA's attorneys had apparently not examined carefully. The lot conveyances from Clearwater Development LLC to the individual buyers had been made through a title insurance company that had, in its commitment documentation, expressly accepted the Eastern Tract's underlying ownership question from its coverage. Because the title examiner at the time had noted an inconsistency in the chain that she had flagged, but that the developer had resolved by providing what turned out to be additional forged documentation. This meant that the title insurance policies held by the individual homeowners did not actually ensure the fundamental ownership question. It also meant that the title company had been presented with forged documents and had, in relying on them, exposed itself to significant liability. When James presented this analysis to the HOA's attorneys at a discovery conference in the spring of 2021, the nature of the litigation changed materially. The HOA's attorney asked for a recess. When they returned, the tone was different in the specific way that litigation tone changes when defense counsel has just spoken privately to their client and absorbed information that requires recalibration. James had also by this point notified the title insurance company of the situation, which had caused that company's legal department to become actively involved. Not on the HOA's side, but on its own, seeking to understand the scope of its exposure and to identify all parties responsible for the forged documentation it had been presented with. Gary Whitmore had been HOA president for 6 years when the litigation began. He had not been involved in the original development fraud. The timeline made that clear, since he had purchased his home in 2013, 4 years after the forged deed was recorded, and had no connection to Clearwater Development LLC or its principals. But he had, in his capacity as HOA president, continued to assert community standards authority over my remaining land, and had sent the violation letter that had, in a practical sense, prompted me to accelerate the legal proceedings. I don't hold that against him personally. He was operating on the assumption that the HOA had legitimate authority, which was the same assumption everyone in the community had been operating on, and which the fraud had been specifically designed to sustain. The resolution of the litigation took 18 months and involved negotiations that I will describe only in outline, since the details are both complex and subject to confidentiality provisions in the settlement agreement. The core outcome was this. The Circuit Court issued a declaratory judgment confirming that the 2009 deed was void and that fee simple title to the Eastern Tract had remained in my family continuously and had passed to me through my father's estate. This judgment, once issued, created a title situation for the 214 homes that required resolution. The individual homeowners held deeds from a chain that had originated in a void conveyance, and their title insurance, as James had established, did not cover that specific deficiency. The title insurance company, facing potential liability on 214 policies, negotiated a comprehensive resolution in which it paid into a settlement fund that was used to compensate me for the fraudulent use of the land and to clear the individual homeowners' titles through a court-supervised quiet title proceeding that gave each of them a clean chain going forward. The HOA's common area holdings were addressed through a separate transaction in which Meridian Ridge Partners, the development company at the Thursday closing I described at the beginning, acquired those parcels from me at fair market value and conveyed them to a newly constituted community association with a clean title chain. The principles of Clearwater Development LLC had not, as it turned out, entirely disappeared. One had died in 2017. The other, a man named Terrence Boyle, who had structured the fraud and arranged the forged documentation, was located in 2021 living in Florida under a name that was not quite his own. The criminal referral James had made to the state attorney general's office in 2020 had resulted in a warrant that Florida authorities executed in March of 2022. Boyle was extradited, tried, and convicted on multiple counts of real property fraud and forgery in 2023. I attended one day of the trial, not because I needed to be there, but because I felt that my father deserved to have someone present who understood what had been taken from him and why the accounting of it mattered. The land is intact. The Eastern Tract, all 1,040 acres of it, is in my name, recorded cleanly, surveyed accurately, and managed the way my family has always managed it, carefully, with an eye toward what it can sustain and what it should remain. The cattle still graze the bottom ground, the timber on the ridge is still standing. The creek still runs the way it ran when Amos Crane first walked the property in 1931 and decided that this was land worth buying carefully and holding for a long time. Gary Whitmore, I am told, still lives in Clearwater Estates, in the home he purchased in good faith in 2013 and whose title is now clean under the quiet title proceeding. I have no quarrel with him or with any of the community's residents. They were deceived the way my family was deceived, by the same man for the same reasons, and the fact that their deception was more comfortable than ours does not make them responsible for it. The HOA violation letter about my cattle fence was withdrawn as part of the settlement, which I accepted without particular emphasis. The cattle didn't know about any of it. They are where they have always been, doing what they have always done, on land that has always been ours. My father would have found the entire proceeding, the fraud, the litigation, the forensic examination, the Florida extradition, exhausting and deeply offensive to his sense of how property and law are supposed to work. He was a man who paid his taxes on time and kept his fences in good repair and believed, with the specific faith of someone who had watched the system work correctly for 60 years, that the records in the county courthouse meant what they said. He was right about that. The system, when tested, did what it was supposed to do. It took longer than it should have. It required more money and more attorneys and more late nights reading case law than anyone should have to spend to confirm what was already true. But the records held. The chain of title, once examined properly, said what it had always said. And the land, at the end of it, is still here, still ours, still exactly what Amos Crane understood it to be when he spent his railroad savings on it in the middle of the Depression, something worth building carefully and holding for a long time.